My Lord, I'm sure it will interest you to know that we have over 10,000 people who have participated in this series so far.
Ah, that's a lot.
10,000 members, yes.
Yeah. 10,000 lawyers.
Across the country, from every state.
That's very interesting.
Okay, it's 3 p.m. now, so we start.
Yeah.
Good afternoon, my Lord. Good afternoon, distinguished, distinguished panelists.
Yeah.
And good afternoon, delegates. Welcome you all to today's session. My name is Tobenna Erojigwe, and I am the chairman of the board of the Institute of Continuing Legal Education of the MBA. Of course, we've all been looking forward to today's session, and we already have my Lord here with us. But I would leave the introductions and formalities for the learned senior advocate, Tola Oshobi. He will be introducing, am I? Okay, you can take over from here. Can you hear me, Tola? Leonard Silk? Leonard Silk, you can take over if I'm freezing.
It's freezing.
Yeah, I'm just asking the Leonard City advocate to take over if I'm freezing. Tola, take over.
I was logged out. I'm trying to log in again. I'm sorry.
Okay, once you log in, you can take over. It's fine.
Okay. I don't know what happened. I just dropped. I don't know. I thought maybe they were rebooting or something on the MBA. I'll join now.
Okay. A few technical hitches. I don't know whether anybody can hear me, but the Leonard City advocate Tola Oshobi will take over from here because my network is somewhat poor. Tola, the floor is yours now.
So far, things are moving. He said they had problems.
Ladies and gentlemen, our speaker for today is someone who needs no introduction to anyone practicing law in Nigeria. But to fulfill all righteousness, I will still like to read the citation of my Lord, the Honorable Justice Bode Rodzvivo. My Lord, the Honorable Justice Rodzvivo attended the very prestigious St. Gregory's College, Lagos, secondary school, Lagos. In 1970, he wrote and passed the advanced level certificate and proceeded to the University of Lagos for his undergraduate studies. He graduated from the University of Lagos in 1974 with honors. 1975. As soon as he was called to bar, he began to practice in his calling, and by 1976, he had become the People's State Council. Shortly after, senior state counsel in the Lagos State Ministry of Justice. He was promoted to the position of principal state counsel in 1984, and in 1989, he became the deputy director of public prosecution in Lagos State. He held this position until 1994 to the High Court on 25th of April 2005. In 2008, on secondment by the government of the Federal Republic as a justice of the Supreme Court of Sierra Leone, at his after his posting, he was appointed a justice of the Supreme Court of Nigeria on 16 September 2010. He has attended various international and professional conferences and is a recipient of several awards. They are very numerous. My Lord retired from the Supreme Court in 2021 and was appointed a member of National Judicial Council. Is happily married to me today. We're very grateful to her. Yes, my Lord, you may go on, my Lord, with your session.
Yes. When I freeze, I think you will inform me. Yes, a Christian newspaper, the salient.
Okay, well, I'll do that, my Lord.
Yeah, the salient issues in appeals against final judgments in the civil and criminal cases. First of all, time to appeal. The Court of Appeal Act of Section 24, subsection 1 provides that when a person desires to appeal to the Court of Appeal from the High Court, they must file the notice of appeal within the time prescribed. Section 24.
You are breaking, my Lord.
Section 24, subsection 2 provides that in civil cases, appeals against interlocutory decisions must be filed within 14 days, and appeals against final decisions must be filed within 3 months. In criminal cases, appeals against final decisions must be filed within 90 days. However, where the notice of appeal is not filed within the prescribed period, the Court of Appeal has power by virtue of Section 24, subsection 4 of the Court of Appeal Act to enlarge the time within which an appellant may appeal. The rules of the Court of Appeal also give the court power to enlarge time for.
My Lord, you are breaking off, sir.
Okay.
We can't hear you, sir.
You sure it's not from your own side? Okay, the Supreme Court Act. Do you hear me? Hello? The Supreme Court Act. Section 27, subsection 1 of the Supreme Court Act provides that when a person desires to appeal to the Supreme Court from the Court of Appeal, they must file the notice of appeal or application for leave to appeal within the times prescribed. Section 27, subsection 2, that is of the Supreme Court Act, provides that in civil cases, appeals against interlocutory decisions must be filed within 14 days, and appeals against final decisions must be filed within 3 months. In criminal cases, appeals against final decisions must be filed within 30 days. However, where the notice of appeal or application for leave to appeal is not filed within the prescribed period, the Court of Appeal has power by virtue of Section 27, subsection 4 of the Supreme Court to enlarge the time within which an applicant may appeal. The rules of the Supreme Court also give the court power to enlarge time for doing anything under the rules. That comes under when a counsel fails to apply for or fails to file his notice of appeal within time, he still has the opportunity to do so under what is called extension of time. Where a notice of appeal is not filed within the time prescribed by statute, an extension of time or permission is not granted to file the notice of appeal out of time, the notice of appeal is incompetent and not valid. See Okoro and the State, 2023, where it says all valid and competent notices of appeal can be given or filed after the expiration or outside the periods of time stipulated under the provisions of Section 27 subsection 2 of the Act, when and only if the periods of time was extended by the court as a condition precedent. Accordingly, the prior permission or leave of the court by way of extension of the relevant period of time within which to give the notice of appeal is necessary and required for the validity and competence of a notice of such an appeal to the court. Without the prior permission first sought and obtained by an appellant for extension of time to appeal before giving or filing a notice of appeal in the court, a purported notice of appeal given or filed after the expiration or outside the limited period of time will be fatally and incurably invalid and incompetent, thereby depriving the court of the requisite jurisdiction to entertain and adjudicate over the appeal. I must say something at this stage also. When you are out of time and you file an application, a motion for extension of time, there is no limit. There is no limit. There is no limit of the time within which you are out of time. For example, I can say you can be out of time for a number of years. The important thing is that the affidavit, so the affidavit supporting the application for extension of time should give good reasons while you are coming after 1 year or after 2 years or after 3 years, after whatever years for that matter. So it all depends on the reasons you have given. The reasons must be enough and cogent to convince a judge on why you are late or why you are coming so late. An appellant who brings an application to file an appeal out of time must show good and substantial reasons to justify the application for extension of time to appeal. In Ungure versus Authority,
you know that again, it's 00, yeah.
2014, where it was, I said, in an application for extension of time within which to appeal, The affidavit in support of the application must be detailed on 1, good and substantial reasons for failure to appeal within the prescribed time, and 2, grounds of appeal which prima facie show good cause why the appeal should be heard, good reasons for delay and arguable grounds of appeal, not necessarily grounds of appeal that will succeed, must coexist before an application for extension of time to appeal can be granted. There are several authorities on this. Then the Trinity prayers. When an application, when an appellant is out of time to appeal and also seeks leave to appeal, the practice is to bring an application seeking what is known as the Trinity prayers for 1, another granting the appellant extension of time to seek leave to appeal against the final judgment, and 2, another granting the appellant leave to appeal against the final judgment, and 3, another granting the appellant extension of time to appeal against the final judgment. See, in Folio Communications Limited, Daily Times, 2021, where a person is a party to an action, case, cause, or matter, and he seeks to appeal against a decision which the law requires him to first obtain leave of court. And if he files his application out of time, his motion or notice must include 3 prayers known as, or usually referred to as, the Trinity prayers. The Trinity prayers are normally couched in words or manner as follows: 1, enlargement of time to seek leave to appeal; 2, leave to appeal; 3, extension of time within which to appeal. In Madaki, one-time Chief Justice Ways did say, supporting this, and the other, several other authorities on this. Now, leave to appeal to the Supreme Court, Section 233, subsection 2 of the Constitution, 1999, grants an appellant a right of appeal to the Supreme Court from decisions of the Court of Appeal in any criminal or civil causes in the circumstances enumerated in the section. Section 233, subsection 3 of the Constitution requires an appellant to seek leave to appeal in all other cases where the ground of appeal involves a question of facts or mixed law and facts. An appellant must seek leave to appeal for the Supreme Court to be seized of jurisdiction to entertain the appeal. Failure to obtain leave, where the grounds of appeal raise questions of mixed law and facts, or grounds of facts alone, the leave of the Supreme Court must be sought and obtained from those grounds before those grounds can be validly raised. In Amani and Balarabe, 2022, the Supreme Court considered the effect of failure to seek leave to appeal when leave is required. The Supreme Court said it has been held in a plethora of decisions of this court that failure to obtain leave where leave is required will render the notice of appeal incompetent. The seeking and obtaining of leave to appeal where leave is required is a condition precedent to the exercise of jurisdiction by the court. There are a whole lot of authorities on that also. Classification of grounds of appeal. It must be noted that a ground of appeal is not classified simply by the name or label given to it, and the court will examine the grounds to determine whether they are actually grounds of law or grounds of fact, or mixed law and facts. In Igbamwen and Asemota, 2022, the Supreme Court examined all the 7 grounds of appeal in the notice of appeal, even though the grounds were described as an error of law or a misdirection of law, and held that they were all grounds of facts, or mixed law and facts, and accordingly struck out the appeal. The Supreme Court had to say, this court has the responsibility to ensure that the grounds of appeal in respect of the matter before it fall within its constitutional competence. In this regard, therefore, a ground of appeal is not let off the hook simply because it is tagged an error of law. This court must be satisfied it is so. The consequences is for not seeking leave where a ground of appeal is of mixed law and fact is fatal to the ground, a host of authorities too. The classification and description of grounds of appeal is a thorny issue which has generated a plethora of judicial decisions on the point. However, the Supreme Court has laid down guidelines for examining and categorizing grounds of appeal. In Akiemi and Odua, 2012, the court said, where a ground of complaint of a misunderstanding by the lower court of the law or a misapplication of the law to the facts already proved or admitted, it is a ground of law. 2, where a ground questions the evaluation of facts before the application of the law, it is a ground of mixed law and facts. 3, a ground which raises a question of pure facts is certainly a ground of facts. 4, where the lower court finds that particular events occurred, although there is no admissible evidence before the court that the event did in fact occur, the ground is that of law. 5, where admissible evidence has been led, the assessment of the evidence is entirely for that court. If there is a complaint about the assessment of the admissible evidence, the ground is for fact. 6, where the lower court approach the construction of a legal term or part in a statute on the erroneous basis that the statutory wording bears its ordinary meaning, the ground is that of law. 7, where the lower court or tribunal applying the law to fact in a process which requires the skill of a trained lawyer, that is a question of law. 8, where the lower court reaches a conclusion which cannot reasonably be drawn from the facts as found. The appeal court will assume that there has been a misconception of the law. This is the ground of law. 9, where the conclusion of the lower court is one possible resolution, but one which the appeal court will not have reached if seized of the issue. That conclusion is not an error in law. 10, where a trial court fails to apply the facts which it has found correctly to the circumstances of the case before it, and there is an appeal to a court of appeal which alleges a misdirection in the exercise of the application of the trial court, the ground of appeal alleging the misdirection is a ground of law, not of fact. When the court of appeal finds such application to be wrong and decides to make its own finding, such finding made by the court of appeal are issues of facts and not of law. 12, where the court of appeal interferes in such a case and there is a further appeal to a higher court of appeal on the application of the facts, the ground challenging such misdirection by the lower court of appeal is a ground of law, not of facts. 13, a ground which complains that the decision of the trial court is against evidence or weight of evidence or contains unresolved contradictions in the evidence of witnesses. It is purely a ground of fact. See further Ikbanwen and Asemota 2022, AIC Limited and Technip and others 2023. The Supreme Court can also suo motu raise the issue of classification and validity of grounds of appeal. However, where the issue is raised by the respondent in preliminary objection, it is their duty to accurately specify the basis of their objection. See Super Ceramic Manufacturers and HEP. The onus is on the respondent to satisfy the court that the ground he objected to is not a ground of law and that it is either a ground of facts or a ground of mixed law and facts, he has to specify the the basis of his objection. Whether it is a ground of facts or mixed law and facts, the ground cannot be of mixed law and facts and of fact as alleged in the preliminary objection. It has to be one, a ground of mixed law and fact, or a ground of fact. It is improper for learned counsel to guide the court on how to determine whether a ground of appeal is one of law, mixed law and fact, or a fact, and then invite the court to undertake a scrutiny of the ground to determine its status. See Ogo and Emir Yedkwe, 2016. A primary objection to an appeal ought to be formally raised and argued than merely directing the court on how to determine the status of a ground of appeal. Having enumerated the guidelines for determining the nature of a ground of appeal, the respondent's counsel ought to have applied the guidelines to the ground of appeal to determine that it is not a ground of law, as he claimed in his preliminary objection. I hope you are hearing me.
Milord, yes, we can hear you, sir.
Right. Now, essentials of a good appeal brief. A brief contains the facts, arguments, and submissions of counsel for consideration by the appellate court. The appellant's brief must be filed first. Then the respondent will file a brief in response to the appellant's brief. The appellant then has the right to file a reply brief to respond to fresh issues raised in the respondent's brief. Any preliminary objection can be raised in the respondent's brief. A well-written brief must contain the following sections. 1, the introduction. 2, the statement of facts. 3, the appeal. 4, the issues for determination. 5, the arguments. 6, the conclusion. And 7, the list of authorities. C, Ports and Cargo Handling Services, O Limited. Megbo Nigeria Limited. These are cases decided in 2012, where this Supreme Court said a brief of argument has the connotation of really concise and succinct expression of the appellant's complaint and the respondent's visit on the issue or issues presented to court for consideration. Clarity, simplicity, and directness of expression are the hallmarks of a good brief. The rules of the Court of Appeal and the Supreme Court prescribe the time within which an appellant and respondent must file their briefs, and any party that intends to file a brief out of time must seek and be granted an extension of time to do so. Now, the ABC of brief writing. C, Engineering Enterprise and Niger Contractor Company at Nigeria versus AG Kaduna State, 1987, where the Supreme Court said, the lawyer confronted with the task of preparing a brief will do well to remember what may be called the ABC of all legal writing, namely accuracy, brevity, and clarity. Now, I start with accuracy. The statement of facts in a brief must be accurate. There should be an honest and straightforward presentation of all the salient and relevant facts of the case. Facts are sacred. What is also important is that the statement of facts must be factual and not argumentative. The facts must be stated as they really and truly are, without undue bias or an embellishment. Unfavorable facts, as well as favorable facts, must be given equal emphasis. Otherwise, the integrity of the brief will have been seriously compromised and the effectiveness of the brief will suffer, as the court may then approach the brief with a degree of skepticism or even disbelief. Honest and frank statement of all the facts, the good and the ugly, will no doubt inspire confidence. The statement of the facts affords counsel a wonderful opportunity to settle the equities of the case in such a way that the court will feel that justice will be done by deciding as is urged by the brief writer. The facts included in the statement of facts must, of course, be facts supported by the record, and there should therefore be a cross-reference on the right-hand corner to the pages of the record of proceedings where those facts can be found. Accuracy thus implies a correct, fair, straightforward, and honest statement of the facts of the case. Brevity. As the name implies, a brief should be brief. It should, however, be short enough to be attractive and yet long enough to cover the substance. The goal is brevity is not easy to achieve unless counsel is very familiar with all the facts and circumstances of the case, can distinguish between the crucial and non-crucial, the important and the incompetent, the crux of the matter and the merely peripheral, the central issues and the subsidiary issues. Brevity does not imply what Mr. Jadwala did in this case. He filed a one-page brief. Brevity here implies a flexible standard of consciousness in relation to the complexity of the case. Everything germane must be included. Counsel writing a brief must bring to bear on such writing time, effort, and professional skill. A lazy or casual presentation of fact is of little help to the court and absolutely of no help in counsel. The goal here is to attain maximum brevity consistent with accuracy and clarity. Clarity. When counsel is easily understood, that is clarity. Clarity begins with straightforward thinking. When counsel does not understand himself, he cannot possibly make the court understand him. Clarity of understanding must therefore inevitably precede clarity of expression. No knowledge, however thorough, of the art of legal composition or exposition will compensate for the want of knowledge of the facts and the law related to the particular case in which counsel is called upon to prepare his brief. Having the facts very clear in his mind and being in possession of the right words to use, clarity becomes easily attainable, but not otherwise. See Hamidu and FRN 2022, the system of brief, the system in Nigerian courts by Nikki Toby, and Manual of Brief Writing in the Court of Appeal and Supreme Court of Nigeria by Nnameka Agu. In Iloksun and Company Limited versus Union Bank 2021, the Supreme Court criticized a 55-page appellant brief as irritating and cumbersome and referred counsel to the ABC of brief writing, expressed in the above quoted judgment of Oputa GSC. Happily, the rules of court have now restricted the number of pages for briefs filed by counsel. Legal effect of poor brief. What is the effect of a bad brief or the attitude of an appellate court to a poorly written brief? An appellate court should not dismiss an appeal or the case of a party only on account of a bad brief or poorly written brief. The Supreme Court said, admittedly, there were substantial flaws in the appellant's brief before the court below, and the court highlighted them. But was the court right to dismiss the appeal because of those flaws? It is my view, with respect, that the Court of Appeal was wrong. There are numerous authorities on the principle that the intelligence or flaws in a party's brief or argument, notwithstanding, an appellate court has a duty to examine the arguments contained therein and decide the case on its merit. See Obiora and Osele, 1989, cited in the appellant's amended brief of argument, is very opposite on the point. The dismissal of the appeal on the ground that it was not argued in the appellant's brief in accordance with the rules and principles governing the writing of briefs, as stated in the judgment, is tantamount to the determination of the appeal without giving the appellant a fair hearing. Therefore, if this were the only ground for the dismissal of the appeal of the court below, the appeal will have been allowed on that ground alone. See Udukwe and the State, 2009. Issues for determination. This is very important. The grounds of appeal against the judgment of the trial court or lower court are contained in the notice of appeal filed by the appellant. Counsel must then distill the grounds of appeal into issues for determination for the consideration of the court. Once issues for determination have been settled, the appeal is then argued on the issues for determination and not on the grounds of appeal. See Ezeuko and the State, 2016, where this court said, where the Supreme Court said the main purpose of formulation of issues for determination in an appeal is to enable the parties to narrow the issues in controversy in the grounds of appeal in the interest of accuracy, clarity, and brevity. Issues for determination must arise from the grounds of appeal. Counsel must ensure that issues raised in their brief must relate to the grounds of appeal. And it is good practice for counsel to identify and state the particular ground of appeal from which an issue for determination arises. Appellate courts often frown upon the proliferation of issues for determination in an appeal. Therefore, one issue for determination may cover and encompass more than one ground of appeal. But one ground of appeal should not give rise to several issues for determination. An issue for determination does not arise from the grounds of appeal. That does not arise from the grounds of appeal cannot be argued before an appellate court. And a ground of appeal not covered by an issue for determination will be deemed to have been abandoned by the appellant. Furthermore, even where an issue properly arises from and is covered by a ground of appeal, if counsel fails to put forward any arguments in the written brief in elaboration of the issue, then the issue will be deemed to have been abandoned. In Ode versus FRN 2008, Supreme Court said it is now settled law, which does not require any authority, that issues for determination cannot be formulated outside the grounds of appeal. Issues for determination formulated must be related to the grounds of appeal. Every issue for determination must be formulated from and related to or distilled from a competent ground of appeal. In other words, an issue not distilled from any of the grounds of appeal is incompetent and must be discountenanced together with the arguments advanced therein. See Bailey and the State, 2016, Mobile Producing Unlimited versus Monopole, 2003. Thank you for your kind attention.
Hello. Okay.
Yeah. Yes.
Thank you, my lord. Hello, my lord. Are you still on, sir?
Yes, I'm on. I hear you.
Okay. Okay. I think you've rounded up, sir.
Yeah. Yes, I am.
Thank you very much, my lord, for the very erudite presentation. It's very extremely enlightening, and we're very thankful to my lord for the time and effort and industry invested in putting this together. I think we will, it was very masterful, and we had the bonus of not only benefiting on this is a criminal litigation training, but my Lord dealt with appeals as they pertain to both criminal and civil litigation. So we got a bonus in that regard. I will call on my colleague, Mr. Mayowa Owolabi, I believe is on, to conduct the Q&A session. Mr. Owolabi, are you on? Can you unmute if you are on? Mr. Owolabi, are you on, please? Can you unmute? Can you take the question and answer session, please? I'm not sure he can hear me. Okay, maybe I will just go ahead if he's not on the call. Okay, I will just appeal to all to our colleagues. Please direct your questions to the Q&A folder rather than to the chat. I suspect some people have been sending questions to the chat rather than the Q&A. Okay, Mr. Owolabi, are you on?
Yes, I'm on. Apologies, I had a slight connection problem. Good afternoon, Lanet Silk. Good afternoon, Milord. Thank you very much for that well researched and well delivered lecture. We're really grateful to you, sir. We will proceed with the questions now. The model that we've adopted over time is that our colleagues are required to ask those questions in the Q and answer room. So if you have any questions, you're at liberty to put them there now. Thank you very much. We'll take them one after the other. Lord, I'm just going to take a minute to look at the questions and come right back to it.
Yeah.
Look, this question is from Sonny Musa, a colleague from Zaria branch. He would like to know the rationale behind not entertaining stay in criminal proceedings as codified by Administration of Criminal Justice Act laws of the various states, respectively. I'll take the question again.
The reason?
He wants to know the reason why. The rationale behind not entertaining stay of proceedings in criminal matters as codified in our Administration of Criminal Justice Act by the various states' laws, respectively.
Yeah. The reason why stay is not encouraged or given anymore is simply because most applications for stay are not made in good faith. These applications are just made to hold up proceedings and delay the whole proceedings. Consequently, when these stays are given, you start seeing straightforward criminal cases in the High Court lasting 5 years before they are completed. So that is why that is not, that's the rationale behind it. Hello, do you hear me?
Thank you very much, my lord. We heard you, sir. Thank you very much, my lord. Godwin Edo, sir, would like to know whether it is compulsory for a party who's filed a preliminary objection to adopt it in his brief. I'm just going to take that again, sir. The way the question is phrased is a bit confusing. Is it a must that the party with a preliminary objection in his brief must adopt it first? What is the implication where he failed to do so during the hearing? This is from Godwin Edo from Uyoba.
No, normally in the appeal court, you start with your preliminary objection, which is already in your brief. You start with that, then go on to the substance of the appeal. But most appeal courts will like you to argue both together. So the situation where it makes it easier for the appeal court. The appeal court takes it away, takes at the conclusion of the hearing and writes a judgment. They first of all look at the preliminary objection, and if it succeeds, that brings the appeal to an end. But if it doesn't succeed, the preliminary objection is dismissed, and the judgment is written on the merits. So long ago, preliminary objections were filed independently of the brief, but nowadays it's done together. You file it together to make things easier and straightforward. But you must argue it first, except you have other directions from the court. But that's the proper procedure to take. Yeah.
Thank you very much, my lord. This question is from Eddie Labefo. My lord, he would like to know whether there's a criteria for granting leave to enlarge time for appeal after an unreasonable period of time, like say 8 to 10 years. Is there a criteria that the court would consider in granting leave in such instances?
When you bring an application for extension of time to do anything, what the court looks at is the affidavit in support of the application. So if you are bringing an application for extension of time after 15 years or 20 years, it is you will know the reason why you took so long. And the judge is supposed to look at that reason and see if it makes sense. You can bring an application for extension of time, no matter how many years has passed. But the important thing, what decides it, is your reason for coming this late. And that is found in the affidavit, your depositions in the affidavit. That's where it is. Yeah.
Thank you very much, my lord. Ugochukwu Tom James would like to know whether the indigent disposition of a appellant to prosecute an appeal can be cogent reasons for court to grant him extension of time to appeal. Milo, did you hear that, sir?
I didn't get that. Whether
okay, I'm going to repeat the question.
Indigent nature of
the question is from Ugochukwu Tom Jones, sir. He would like to know whether the indigent or poor disposition or poverty can be used as a ground for applying for extension of time on behalf of an appellant.
No, I put that in another way. Yeah, in a way, it could be. And the appellant was finding money, and he had not found enough, or something like that. Or you are not properly briefed. It could be, but that really depends on who the judge is, because that granting that application is discretionary. I may think that I may say that is a grant. You may say no, that's not a grant. So it's more discretionary.
Yeah, thank you very much, my lord. This question is from Adeniran Dokas. She would like to know whether a party can canvass an argument in his brief and rely on a court of appeal decision where there are no Supreme Court authorities on the point.
Oh yes, very much so. Very much so. In such a situation, the highest court that has decided on what she's relying on is the Court of Appeal. She's perfectly within her rights. Yeah.
Oh, my Lord. It looks like a lot of our colleagues are more interested in the grounds for applying for extension of time. Most of them are now asking specific questions relating to situations it looks like they found themselves. Let
me say something on this extension of time.
Yes, sir.
Can I go ahead?
Yes, sir. You can go ahead.
When you are out of time, do you hear me?
We can hear you, sir. Please proceed, sir.
Yes, when you are out of time to appeal, you bring a motion or notice supported by an affidavit. And this motion or notice must state clearly why you are coming so late. Why you are coming so late. And as I said in my paper, it must, what did I say again? Wait a minute. Let me read it out so you get it properly. Yes, I say in an application for extension of time within which to appeal, the affidavit in support of the application must be detailed on one, good and substantial reasons for failure to appeal within the prescribed period. Now, if you are coming after 5 years, you should go and find a good reason why you are coming after 5 years. I can't find that for you. You should have a good reason to convince the judges to allow you to appeal. Then 2, grounds of appeal, which prima facie show good cause why the appeal should be valid, should be heard. Good reasons for delay and arguable grounds of appeal, not necessarily grounds of appeal that will succeed. And these 2 things I've spoken about, they must coexist before that motion can be granted. I think that is straightforward enough. So what really is the question?
No, this particular participant wanted to know whether it was okay to only just state that you ill health was the grounds for the extension of time without attaching any form of...
To say what? I didn't get it.
Ill health.
Ill health.
Ill health, yes. He wanted to know whether it was okay to just depose to facts that you were out of time because of ill health without attaching documentary evidence to prove those kind of assertions.
No, you must attach documentary evidence. If you say you are ill, if you say you are ill without documentary evidence, obviously the adverse party will object to it. They will say things are like you are lying and things like that.
Yes, you haven't given the court enough material to exercise the discretion that you seek.
Perfect.
Thank you very much.
Perfect.
This question, sir, is from Clifford Chukwu. He would like to know whether it is proper for a trial court during proceedings to record only answers given by a witness without the questions which led to such answers.
No,
he wants to know whether that's good practice.
You give the answers. To give the question and the answer is a bit difficult. But nowadays, we have this verbatim reporting in most courts. So questions and answers are there. But for the lawyer, for the judge to say question, answer, that's a bit difficult to. Yeah.
Okay, sir. I don't know whether this flows directly from your presentation, but this question is from Al-Hassan Muazu. He wants to know whether the 7-day period of appeal by prosecutors, as enshrined under the Prosecutors Act number 10 of 1963, is constitutional.
7 days to do what?
7 days period of appeal by prosecutors as enshrined under the Prosecutors Act of 1963. He wants to know whether this is constitutional.
Or what court to what court?
Unfortunately, the details are sketchy, and that's why I stated that I'm not sure this flows directly from your presentation.
No, what I'm saying is that if you say there is a law which says a prosecutor has 7 days within which to appeal, we have to know from what court to what court.
Unfortunately, my lord,
but as it stands like that,
the question doesn't go that far, sir.
Well, okay, if we can answer it on how far it goes, there's no, if you want to appeal from one court to the other court, it's 14 days in interlocutory appeals. I've never heard of 7 days. I've never heard of that. It may be some electoral act, but normal court, it is 14 days to appeal in interlocutory appeals, and 30 days for criminal, and 90 days in the normal appeals. Those are what is in the Constitution. There's no 7 days period for prosecutor to appeal in the current Constitution. There's nothing like that.
Thank you very much, my lord. But this question is from Tope Akpaneshile. She would like to know how to critically read a judgment in order to determine the grounds of appeal. How to critically read a judgment in order to determine what constitutes grounds of appeal.
You see, apparently the person, the discussant who gave that question is the appellant. Am I right?
Yes, it's the appellant, the proposed appellant.
Yes. When you want to appeal, you have to read the judgment thoroughly to see what part of the judgment is wrong in your own mind. That this is wrong, this is wrong, this is wrong. It is those, let us say, you find 3 distinct things that are wrong. You file your grounds of appeal from those 3. Let me give you an example. 1, the judge did not have jurisdiction to hear this case. That is 1. 2, how the judge misdirected himself or misapplied the law. That is 2. 3, if the judge had considered my evidence, where the judge overlooks evidence and things like that. That is how you get your grounds of appeal. Then they fall under the canopy of misdirection as regard law, facts, or mixed law and facts. That's how it goes. And it is from those grounds that you distill it further to bring out the issues, the real issue. The real issue here is the judge did this, the judge did that. Those type of things. That's how you get your issues.
Thank you very much, my lord. This participant would like to know what is the fate of a record of appeal which was transmitted by the registrars of the court outside of the time allowed by the rules? Will the court allow such record? It says, what is the fate of a record of appeal which was transmitted by the registrar of the court outside of the time allowed by the rules?
I have not really seen anything done or objected to, provided both counsels have no objection to it. But I cannot see counsel coming to court to make that an issue, that the record of appeal was transmitted outside the time provided by the rules. I don't think that's a strong point. Most registrars of the court below that transmit the record of appeal to the Supreme Court, they normally send something like a letter that looks like an affidavit saying why they are coming at this time or that time. And most appeal courts do not make that really an issue, except the other lawyer is opposing it and saying because it was late, it is not correct or things like that.
Thank you very much, my lord. This attendee, who is anonymous, would like Milord, to enlighten us on what constitutes mixed law and facts, and at what point leave of court is required. You would also like to know how to determine what constitutes mixed law and facts and what constitutes points of law alone.
That is exactly what I said in the paper. You see, to determine mixed law and facts, or facts alone or law alone, is not an easy thing to do. There are several lawyers you will go to that will argue that this is mixed law and fact. No, that is law and facts or something like that. But the important thing, or the way to go about it, is to read there are quite a number of authorities on how to distinguish it. So the proper thing to do is to get hold of these authorities, and there are several. If you read them, you will know how to listen. And I gave up to 10, up to 14 instances of how to find it. But I must warn, even the Supreme Court has said it several times, that it's not as easy as it appears. For example, where a ground complains of a misunderstanding of the lower court of the law, or a misapplication of the law to the facts already proved or admitted, that is a ground of law. So I can go on, but I will, to save time, if you read Akiemi and Odua Investment Co. Limited, 2012, and you will see several authorities on this referred to in that judgment, 2012 Supreme Court. But if we go on like this, like if you bring a ground now, that is, and you ask 4 judges or 4 lawyers, what is this? Some will say it's mixed law and fact, some will say it's law, some will say it's this. So that's how intricate it is. It's a skillful thing. But when you read these authorities and things, you also will get a hang of it. Yeah.
Thank you very much, Lord. My Lord, this is a question from somebody who his name is called Sunday Edward from the Abuja branch. He would like to know, he's of the opinion that the Supreme Court, in most cases, refused to grant leave to appeal against judgments of the Court of Appeal, especially when the judgments or findings of the courts below amount to concurrent findings. What can a counsel place before the Supreme Court to get?
You see, concurrent findings. Okay, go on.
Look, I'm just going to frame questions, sir.
Yeah.
So he's of the view that whether are concurrent findings, in most instances, the Supreme Court does not grant leave to parties to appeal. So he's interested in finding some place before the Supreme Court to get the court to grant leave to appeal in the face of concurrent findings of the 2 courts below.
Your affidavits in such a situation will show the grave error in the 2 courts below. That's what it will do. Because the Supreme Court is very reluctant to upset concurrent findings of facts. That doesn't say it doesn't upset it. It upsets it at times when they are perverse. But if you want to get the Supreme Court to grant you leave to appeal, you must show that the judgment of the 2 courts below are manifestly perverse, which is not easy at times. Yeah.
Thank you very much, my Lord. There's a very long question here. I'm trying to find out what the question is because it's really long. It reads like a statement rather than a question.
See that?
Now, this question is from Felix Elijah Nana. He wants to know what is the fate of a notice of cross appeal where the main notice of appeal is amended. Would time begin to run against the notice of cross appeal when the notice of the main appeal was amended? In other words, would the notice of a cross appeal be deemed properly filed upon an order of extension or time in respect of the amended main notice of appeal?
Yes. The notice of appeal, the main appeal was filed. Then the cross appeal was filed. Then the notice of appeal was subsequently amended. All what is happening doesn't affect the cross appeal. The cross appeal is valid and very much in order. Yeah.
Well, sir. Question is from Ibrahim G. Labaron. He wants to know circumstances under which the Supreme Court of Nigeria would review its own decision or set aside its own previous decisions.
That's a big one. That calls for 7 judges of the Supreme Court. And 7, and it is rarely done. You have to make a formal application to the Chief Justice of Nigeria, telling him that that judgment of the Supreme Court is wrong and you want a review. Most Chief Justices never do that. They just remain with the judgment as that it remains on the record, because there are quite a number of judgments in the Supreme Court that I think are not quite right from what we hear and see all over the place. But they are hardly ever reviewed.
Yes. Well, thank you very much, my lord. This question is from Ewiri Aliemeke. He wants to know whether it is proper procedure for an appellant who is out of time to file his notice of appeal first before bringing a motion to regularize the notice of appeal. He wants to know.
You file the application for extension of time to file notice of appeal. Hello.
Yeah, we're here. We can hear you, sir. We can hear
or
you.
you can file it together with you file an application for notice of appeal, and you attach the notice of appeal so that they know you are serious and try to make up for time.
This is from, yeah, we heard you, sir. Thank you very much, sir.
Yeah.
Abdul Malik, sir, wants to, he thanks your lordship for the wonderful lecture, and he wants to know whether it is safe to seek leave to appeal when one is not sure whether its ground of appeal is that of a fact, law, or mixed fact and law. Is there any downside in applying for leave when you do not need leave?
No. If you apply for leave when you do not leave, it will be overlooked.
Thank you very much, my lord.
But if you appeal where you need leave and you didn't get leave, your appeal will be struck out.
Now, this is a question which seeks to challenge the laws as they are right now and the jurisprudence behind it. Abila Chusak wants to know whether the current practice mandating trial courts to defer rulings on preliminary objections till judgment in criminal matters based on the provisions of the ACGA is not tantamount to a breach of fair hearing against the defendant, particularly in view of the important issue of jurisdiction.
Yeah. What deferred rulings to when?
Now, the participants tends to suggest that ACGA that the courts are enjoined to defer rulings on preliminary objection, changing criminal matters to judge. View is this how to
I don't hear you. You're breaking up a lot.
Apologies, my lord. I'm just going to repeat that question, sir.
I hear you now.
Okay, the participant wants to know whether the provisions of the ACJA, which mandates trial courts to defer rulings on preliminary objections till judgment, isn't tantamount to a breach of fair hearing against such defendants.
No, I don't think so. That is just to stop wasting of time, to just make everything flow. At the end of the day, you hear the ruling on the preliminary objection. Could you wait a minute? Could you just hold on for 1 minute?
Okay, sir.
I want to just use myself.
While we wait for my Lord, I think somebody mentioned that I wasn't very clear when I was reading the citation. I don't know how long my Lord will take. Maybe I should go through that again. I don't know what you think, Mr. Owolabi.
I think you could do that so that we use up that time. That would be nice. Brilliant idea. We could repeat.
Okay. I hope my Lord doesn't come back whilst I'm reading it. So just a second. I'm just trying to bring it up. So I believe I'm clearer now than I was earlier on. My Lord, the Honorable Justice Rhodes Vivor attended the very prestigious St. Gregory's College, Lagos. In 1970, he wrote and passed his advanced level certificate examination and proceeded to the University of Lagos for his undergraduate studies. He graduated from the University of Lagos in 1974 with honors, and thereafter he was admitted to the Nigerian Law School and was called to the bar in 1975. As soon as he was called to bar, he began to practice in his calling, and by 1976, he became a pupil state counsel. Shortly after that, in 1978, he became a state counsel, and by 1982, he had become senior state counsel in the Ministry of Justice of Lagos State. He was promoted to the position of principal state counsel in 1984. And in 1989, he became Director of Public Prosecution of Lagos State, a position he held until 1994. On 18th February 1994, he was appointed to the bench as a High Court judge in the High Court of Lagos State. After many years of experience on the bench at the High Court, he was elevated to the bench of the Court of Appeal on 25th of April 2005. In 2008, on secondment by the government of the Federal Republic of Nigeria, he was posted to Sierra Leone Judiciary as a justice of the Supreme Court of Sierra Leone. Upon his return to Nigeria after this posting, he was appointed a justice of the Supreme Court of the Federal Republic of Nigeria on 16 September 2010. He has attended several international and local professional conferences, and is a recipient of many excellent awards, prominent among which are an honorable award by the Lagos State government for outstanding contribution to the Lagos State Ministry of Justice in 2003, and the Lagos State Judicial Merit Award in recognition of his invaluable service to the High Court of Lagos State in December 2003. The Honorable Justice Rhodes Vivor retired from the Supreme Court in 2021 and was appointed a member of the National Judicial Council in the same year, a position he continues to hold till date. The Honorable Justice Rhodes Vivor is happily married to Mrs. Adedoyin Rhodes Vivor, Senior Advocate of Nigeria, and they are blessed with 3 children. Sorry, my Lord, we decided to read your citation again because apparently the delivery from my end was bad. I had internet problems when I earlier read the citation. So some members had complained. So we took the opportunity to just read it again while my Lord was offline. So Mr. Owolabi, I hand over to you.
No, wait a minute before you go. Hello?
Yes, sir.
I just wanted to say you forgot to say that I'm the recipient of the CFR. I'm a CFR.
Oh, I'm so sorry, my Lord. Please forgive me. I was relying on the information from the NJC website. My Lord is also a recipient of the CFR, Commander of the Federal Republic of Nigeria. Much obliged to my Lord for that clarification.
Thank you very much. Thank you. Yes, I'm ready to go.
Thank you very much, Lionel Silk, for reading Milord's profile again. I wasn't here at the beginning, so that was really good for me. You're welcome back, sir. One of the participants would like to know what is an omnibus ground of appeal, and how is it applied?
Not really referring to something real substance. It's something in general. General. I can't give an example now. That the weight of evidence is against the. I don't know how to put it. Let me see. When you say something like judgment was given against the weight of evidence, you get it?
Exactly, my lord. Yes, we get it without more. That's omnibus.
Yeah.
Thank you very much, sir.
Yes.
My lord, it looks like we've run out of questions, but we still have a bit of time. So I'm just going to tarry a bit so that it's not every day that we get to see you, sir. So we would try as much as possible to use up all the time that we've been allotted.
Right.
A few people are asking for citations of the cases that you cited. I can assure you that we would circulate the slides. We would get them from my lord. The citations will be there. And if you did get the cases, I'm sure that any of the search engines would put the citations.
I could send it to you to the email.
Thank you very much, my lord. We would retrieve it from you, sir.
Yeah.
If I don't know if my lord to send it to the WhatsApp platform or anyway in any manner convenient for my lord, we will circulate it.
Yes, what WhatsApp platform? This the one I have.
Yes, the one for the this training program. My lord was added to the, or you can send it to me or any other member. If my lord was my lord, yes. So we'll circulate it from there to our colleagues.
I will.
My lord, this question, sir, is not a question that you're interested in commenting on. Nelson Sulola is of the view, would like to know what your views are on the concept of regional Supreme Courts. And he's asking these questions in view of the congestion that we have at the Supreme Court. It's basically like, is Nigeria ripe for regional Supreme Court? Is this something that we're looking into?
You see, I personally that most of the cases that get to the Supreme Court should never have gotten that far. Most of the cases should end at the Court of Appeal. What are the cases that should go to the Supreme Court? Real constitutional matters, real very, very serious matters. How can you go to the Supreme Court to decide mundane issues, very simple issues? That is what I think. And the Supreme Court, if you ask me, should be as it is, but with fewer judges, about 16, as it always used to be. I don't support regional Supreme Courts, except you have a situation where the country is into 6 geographical regions, and the constitution is rewritten to give them different degrees of powers, like what goes on in the United Arab Emirates, where you have Dubai, you have Abu Dhabi, you have Sharjah. If you have something like that, you have a situation where we have a loose center, and all the confederated states koto to that center. But speaking for myself, as the constitution is today, I will support a regional. I will support regional Supreme Court, because it will cause for too much proliferation, too much conflicting judgments, and all what. Yeah.
Thank you very much, Milord, for sharing your views on issues of that nature. So this question is from Stanley Madrobuchi Ofuegu. He says he's dealing with a situation like this and would like to hear your views. he says that where the Court of Appeal held that an appeal was filed out of time, but went ahead to hear the appeal on the merits, but at the end of the day, still ended up striking it out for lack of leave being sought by the appellant. Can the appellant refile the appeal after seeking leave of court, considering that the court had already delivered judgment on the merits before? Will the judgment...
How did the court go ahead to deliver merits on a notice of appeal that was filed out of time? That's where the problem starts. If the appeal was filed out of time, that is where the whole matter ends. I don't see how the merits and dismiss the appeal. You get it? I don't see how he could do
that. We understand it, sir. And apparently that appears to be his dilemma, because he also thinks that they should just have stopped there. But he says they went ahead to make pronouncements on the merits, but yet still struck it out on the grounds that leave was not sought. He's now caught between whether or not filing that application for leave again.
I didn't get that.
He's wondering whether he can. Now, the participant says that is exactly the situation that he has found himself. Milord, can you hear me, sir?
Huh?
Daniel, can you hear me? I'm trying to ascertain whether the problem is from my end.
I can hear you, Mr. Ola. My lord, can you hear us?
Yes, I hear now.
Okay, my lord. Thank you, my lord.
Okay, sir. So, my lord, the conundrum that this colleague of ours has found himself is that it's exactly the same sentiments you expressed, that the court should just have left it at that when they found that the application was filed without leave. But he says they went ahead to dwell on the merits. So he's wondering that, considering that they eventually still struck it out on the grounds that leave was not sought, should he just approach that same court for leave? What is fair is that having touched on issues on the merits, won't it be caught up by the doctrine of estopel on the grounds that they have dealt with the issue?
Yeah, they have dealt with the issue, but I don't know what he's seeking to get after the court has ruled that his appeal was out of time. I mean, if he goes to the Supreme Court, that's what they will tell him. They will say, go back to the Court of Appeal and sort yourself out. But if he goes back to the Court of Appeal, he'll have problems, because the Court of Appeal will say, we have even decided the case on the merits. So even if we give you leave to appeal, you're out of time. We have decided on the merit, and if this appeal comes before us, it is the same judgment we are going to give you. So I don't think he has any chance there. I don't think so. Except he just wants to try.
Thank you very much, my lord. This question is from Hussein Tijani. He's of the Lagos branch of the NBA. He wants to know whether statements and evidences before the court, which had already gone in before a charge was amended, are still relevant before the court? Or is there a need to recall every witness to represent the statements and lead evidence afresh?
No, if you recall witnesses to lead evidence at fresh, that will be taken. That will be rehearing your case. What are you amending?
No, the point is that.
Huh?
No, this is the question. So I'm just going to repeat the question for clarity.
Yeah.
It says in situations where statements gone before it.
You are breaking, Mr. Olabi. You're breaking. I don't think my lord can hear you.
Gone in before. Over there.
You are clear now, but
can you hear me now, Lionel?
We can hear you now.
Okay. Okay, sir. I was just trying to put the question in context. The situation where this counsel has found himself is that the evidence and statements are gone in already. He wants to know, the prosecution has now amended the charge. He wants to know whether the evidence that has gone in already will still be relevant, or they have to start afresh.
It depends on what the amendment is. and a judge won't allow amendments that will affect all what has gone in. How the prosecutor is amending the charge, it cannot materially change the color of the prosecution so far. It can't. What is he amending? Prosecution normally amend charges to change, to add a charge or to, yes, that's what they do. But I don't see how the prosecutor can tender a lot of statements and exhibits and amends the charge to remove all those documents. That is starting the case all over again, and no judge will allow that. Judge will never allow that.
Thank you. Thank you very much, my lord. This question is from Choluwa Ifekoya. He says, good afternoon, my lord. I actually have two questions. In your experience, what are some of the common errors or issues that arise in criminal law appeals? And how can they be effectively addressed?
Well, the problems that arise in criminal law appeals.
Common errors that you, from your experience, you observe.
What I have seen is that most criminal trials in Nigeria, let us restrict ourselves to things like, all right, let me put it this way. Most defense lawyers or most lawyers are not too much into criminal law in Nigeria. I don't know why, but they're not much into it. So you see that the investigation done by the police is never good enough. Take something like armed robbery and those type of things. They just come, the file is so, hardly anything inside the file. What you just have there are confessional statements and things like that. Right. If you have a situation where lawyers decide to go and contradict all those by doing their own investigation,
We've lost you, my lord.
Yeah.
like you have in places like Iran. Do you hear me? Do you hear
We
me?
can
I hear you now. We lost you for a second, sir. But
Yes.
you're back now.
Yes, what I'm saying is that you see most of these criminal trials, I'm restricting myself to things like armed robberies, because a lot of that comes on, and there are so many things that go on there. There's hardly any investigation. But if you talk criminal trials generally, that is broad. You have lawyers that are interested in criminal trials when the accused person is really a man of straw. But when you divide these criminal trials into the ones where the only thing used against the accused person are things like confessional statement and things like that, there's very little the defense counsel can say on appeal. Very little. Because all those confessional statements always end up with a trial with a judge. He says he believes. He gets to the Court of Appeal. The Court of Appeal says, well, the trial judge saw the witnesses, he saw their demeanor and all that, he admits it. He gets to the Supreme Court, the same thing. So, doing criminal appeals in Nigeria on things like armed robbery the hands of the lawyer are tied. If the lawyer doesn't go out of his way to do his own private investigation to see what be done to help the accused.
My lord, this is also a general question. This is a general question, my lord, and this participant would like to hear your views on what can be done to avoid conflicting judgments of the Court of Appeal.
My views on what?
I would like views on conflicting judgments of the Court of Appeal.
Conflicting judgments.
Yes, conflicting judgments of the Court of Appeal. Yes, my lord.
You see, they're about, do you hear me?
We can hear you now, sir.
Yeah,
But
there are about 80 judges in the Court of Appeal. There's
my lord,
no how.
we lost you. Your
judges
connection.
Yeah, my answer to this is that it's very difficult to have 80 judges not giving conflicting judgments. And another reason for conflicting judgments is that these judges think, have the mind of their own, and they see things differently from other judges. Yeah.
I think
Thank
we
you
will
for
take.
Did you hear me?
We can hear you, my lord.
We heard you, my lord. We heard you, my lord. But your connection is actually poor. But we got the latter part of your comments.
Yes, what I was saying is that when you have about 80 judges, there are bound to be conflicts in their decisions. And that means that they are thinking. They're not just copying what has been done before or trying to play safe. They too are thinking and looking at things properly or from their own view. Yeah.
Okay, Mr. Olami, I think we should take just 2 more questions and round up, except you have any particularly, so that we can, I think we've taken a lot of my lord's time, so that we can round up.
I'm just going to ask one last question, my lord. The question, sir.
Hello.
One last question, my lord. Second.
Yeah.
My lord, just give me a second.
Hello. Hello.
My lord, we're here. One second, my lord.
Okay.
Now, my lord, this is the final question for you, sir. And it's from Felix Elijah Inanna. It's not also a legal question per se. It's just a question that you would like to know what your personal views are. My lord, what's your opinion on this current practice of the appellate court awarding huge costs against counsel personally for filing suit considered in penal court to be frivolous? Is this not an affront to the constitutional right of fair hearing, vis-a-vis the right to approach the courts in an unhindered and unfettered manner?
No, the few instances I saw in the Supreme Court where they awarded $1 million and $30 million are cases that present facts, and what they're asking for is something that the Supreme Court has dealt with over and over and over again. So that is annoyance. Do you know that in some jurisdictions, especially a place like England, the judge will ask you, have you read so and so case? If you make the mistake to say you have read it, you'll be reported, I argue the way you argue, you'll be reported to the bar. You may be disbarred or whatever. You cannot, those cases, go and check them out. Those are cases where the Supreme Court has ruled on it. It's just like this 180 days thing where the electoral tribunal at first instance has 180 days to decide a case. They decide it in 180 days. Then you come to the Court of Appeal to say you want the case to go back to the tribunal, for them to decide this. And you know fully well that time has run out. And you argue this all the way. You see, those type of costs are given when, in situations when it is so clear that either you are coming to waste the time of the court or you are just coming to play games. So I support it.
Thank you very much, my lord. My lord, I also support it. I think that we'll be better off when we hold ourselves accountable. Like you rightly said, outside of here, we don't have the kind of congestions that we have because lawyers are held accountable to a higher standard. And the earlier we begin to hold ourselves to those same standards, we're all going to be better off for it. This is a very convenient point to say thank you to you. We will end the session here and now, but before I hand over to Mr. Shobi to thank you formally on behalf of the ICLE of the Nigerian Bar Association, I noticed that a lot of people are saying they would like to be added to the platform. I think the WhatsApp platform, I think that's from the comment made by Lanet Silk. There is no special platform for this training. The platform the Lanet Silk was referring to is the faculty platform for the ICLE. It's not for members of our colleagues. So please, there is no special, you're not missing out on anything. Just stay in your WhatsApp platforms in your respective branches. The ICLE chairman from all of the branches will ensure that whatever needs to be passed across down the line gets to you all. Lanet Silk, I'm going to yield the floor to you now to do the vote of thanks.
Okay, thank you very much, Mr. Wolabi. Yes, just to confirm what Mr. Wolabi has just said, the WhatsApp platform is just for the faculty and for the ICLE, but we circulate information within that platform. Once we receive all the materials, including my Lord's presentation, once we receive it, we will send to all members of the NBA that registered for this conference. We'll send it to you by email. And as Mr. Wolabi said, you can also liaise with your branch ICLE chairman for the material. Of course, all the presentations are also available on the YouTube channel of the Nigerian Bar Association ICLE. So you can go back and watch it. Every single session will be uploaded to the Nigerian Bar Association ICLE YouTube channel. So you can see it there in addition to sending in addition to circulating it to the emails of registered members or accessing it through the chairman of your respective ICLEs in your branches. Before I do the vote of thanks, we have some other members of our faculty here. We have Professor Nasiru Aliu Adamu, SAN, here. I don't know if, Prof, you have any interventions in terms of this topic before we just round up.
Thank you, Leonard. I'm sorry, I am on transit. That is why. Sorry. My Lord, good evening, my Lord. And unfortunately, I'm on transit, but I have gotten part of my Lord's paper. Unfortunately, I had wished that I listened to the entire paper of my Lord presented by my Lord himself. In any way, my Lord, from the little I have gotten, I'm really well enlightened, and I believe my Lord have done justice. In fact, including what I did not expect my Lord to cover, my Lord has covered. I pray for my Lord to live long and continue to uplift to the profession, and may Almighty God continue to give you strength and the wisdom, my Lord, to continue to support us. Because my Lord, always will remember you, my Lord, for being what you are and for what you have helped the profession, my Lord. So, my Lord, thank you very much, and I must say that we are honored. How the Lord is. Thank you, Lord.
Thank you very much.
Okay, my Lord. I just want to join Professor Aliu Adamu, member of our faculty and also one of the organizers of this training and a member of the NBICLE, in thanking my Lord very profoundly. I found the training very enlightening, particularly the areas where my Lord spoke about the presentation of facts. I find it very useful because we get an insight into how the mind of the judges work and how they view presentation of facts. Of course, as my Lord said, facts are sacred. Sometimes you think you are being smart by presenting the facts in a skewed manner that favors you. But obviously, that also could have a downside with the judges in the way they perceive the presentation of your case. I also found my Lord's presentation on the rules of brief writing extremely enlightening. striking the balance between brevity and, of course, also being clear, precise, concise, and dealing with all the issues and the facts. My Lord, this is the most exhaustive treatment of the difference between grounds of mixed law and fact that I have ever encountered. My Lord was extremely detailed, and I think this is one of the big issues that appellate lawyers have in trying to distinguish between grounds of mixed law and fact. My Lord made about 14 different distinctions and explanations, examples, which I found very enlightening, in addition to the several cases that my Lord referred us to. So, my Lord, this was very useful to me personally, and I urge our colleagues to go and listen to this again on the YouTube channel, and also on the paper presentation of my Lord when we circulate it. I think these are gems that will help us very much in our practice. I thank my Lord. I didn't expect anything less. If I'm not taking too much time, and I'll be permitted just a few seconds of my own personal experience with my Lord. I practiced before my Lord when he was in the High Court of Lagos State. Practice in Lagos State then was a lot more difficult than it is today. I remember in those days, half of the time we had power issues, and once there was no power, Lagos State government, I think they have an ITP that supplies power to the Lagos High Court and the Court of Appeal today, so we hardly have power issues. Once there's a power issues, the court doesn't sit. We didn't have as many judges then as we have now, and the judges were over, in my view, even today, I think they're overburdened, but then it was even much worse. And we also did not have the front-loading rules, which had expedited to a degree matters. But my recollection of my Lord, on Mondays, this might sound surprising, we used to call Monday call-over days. And on Mondays, some judges had over 70 matters, mostly for mention, but had over 70 matters. That's for you to know how burdened the judges were in Lagos State in that day. But my experience with my Lord has, and I say it every time, I've said it all throughout my practice, my Lord had uncommon capacity for hard work. I don't know where he used to get the energy from. If you are before my Lord Justice Rosevival in those days, and I've testified to this everywhere, you can be sure your matter will be heard. If your matter doesn't go on, in spite of the very difficult conditions, in spite of the volume of work, if your matter doesn't go on, then it's not my Lord's fault. It's either the fault of it's invariably the fault of the lawyers. In fact, if your matter is for mention and you're both ready to go on, my Lord will take you, he will hear you, he will deliver his ruling on time, he might even deliver his ruling right there and then. So in my earliest years of practice, most of the contentious applications I argued and so on were before my Lord, because my Lord would always go on. And I knew that when I was appearing before my Lord, I had to be ready. It wasn't one of those courts you could go to and you were not ready, because my Lord was always ready. And so you also had to raise your game if you were going to appear before the Honorable Justice Rosevival. My Lord, I thank you very much for your time. I thank my Lord for the industry my Lord invested in preparing this paper. We pray that we will continue to be able to, because I know my Lord is retired, but my Lord is not tired, and my Lord has a lot of knowledge to impart to the profession. And I hope that my Lord would always be available whenever we come calling, either as the ICLE, the MBA, or any other unit of the profession, to drink from the well of my Lord's knowledge. We thank you very much, my Lord. My Lord, I wish you a very pleasant weekend. I thank all the members of the faculty for dialing in. I thank Professor Nasir Ali Adamu, Mr. Maiwo Labi, and all the other members of the faculty. I thank our colleagues from across the country that dialed in, where knowledge is a continuous process, and we have to continue to acquire knowledge and share knowledge amongst ourselves. I thank you for the sacrifice of joining in. I wish everyone a very, very pleasant weekend. Thank you once again, my Lord.
Thank you very much for inviting me, and I hope I contributed to the satisfaction of most.
Beyond that.
Thank you very much.
Thank you.
Bye, everyone.
Thank you. Bye, everyone. Thank you.
Bye. Where's my phone?